All right, let's start. Good morning. Welcome to all of you who've logged on. Welcome to all our subscribers and their guests. As you probably know, my name is Bruce Robertson, and on my left is Alan Rycroft. And we're going to take you through in the next hour or so. I think we'll probably talk, depends how long Alan is, but we'll probably talk for about an hour. And the focus of this webinar is based on the large number of helpline queries that we have received over the last year dealing with dismissals for operational requirements. And so what we're trying to do in this workshop is give you a practical guide to ensure that you could deal with operational requirements dismissals in a fair way, in compliance with your obligations under the Labour Relations Act. And we're trying to answer a lot of your practical nuts and bolts type of issues. Just before we get into it, I just want to share screen with you and go into work law. You should be seeing the work law homepage on your screens. There it is. And if you scroll down to precedents and the drop-down menu that it gives you, if you go down here, in the last year, this is quite new on work law, we've introduced these retrenchment guidelines. And quite a lot of the stuff that we're going to cover in this webinar is on work law. So this is available to you as subscribers. And just to, you can probably see I'm not sure how small or big the print is on your screens, but what's compiled here are very explicit practical retrenchment guidelines, which takes you through the whole retrenchment process. There's an outline of the Section 189A procedure. As you know, Section 189 has two parts to it, the normal 189, and then the 189A, which is for larger retrenchments. We think it's one of the poorly drafted sections of the Act. It's quite complicated, and this gives you an outline of how to implement and apply Section 189A. There's a retrenchment procedure checklist, which we've given you. There's a draft notice to consult. This Section 189.3 notice is a key part of the retrenchment process. And we've given you a draft that you can adapt to suit your own circumstances. Equally, there's a draft retrenchment agreement. If you were to reach agreement with your union, I'm going to just open that. And it takes you into the draft agreement. And we've given explicit instructions to you as to how you would adapt and implement this draft. And all the instructions are in red. I'm not going to show you the whole agreement, but if you look down it in Clause 1 and Clause 2, you can see we're giving you instructions and guidance as how you would go about implementing this draft agreement. Just for some reason, work law is lagging. But what you've got there is a whole series of very helpful guidelines which you can use in a retrenchment situation. So please use those guidelines. They're there for you to use if you need them. Let me give you then, I'm going to share screen again. This is an outline of the presentation that we're going to take you through. Firstly, we're going to look at what constitutes a fair reason to retrench. Secondly, who do you need to consult with? Thirdly, the notice to consult, what needs to go in that, and some of the key issues around that. Fourthly, what do you need to consult about? Fifthly, a particular question, can you retrench to reach employment equity sector targets? 6, when can the employer act on a unilateral basis? So if you haven't reached agreement with your employees or your union, when can you proceed on a unilateral basis? And lastly, we're going to end off with looking at ensuring that you understand the different channels for processing disputes under the Labour Relations Act. So those are the 7 broad headings under which we're going to deal with the practical issues that we think are key. In the process of that, we'll also cover some of the key judgments which have come up over the last couple of years dealing with these issues. Let's start with a definition of the dismissal for operational requirements. It says dismissal, that's a dismissal due to the employer's economic, technological, structural, or similar needs. So just some examples: economic, perhaps a drop in demand for what you do. Technological, there might be new equipment which requires fewer employees. Or it could be structural. There might have been a merger or a restructuring of your operations. So those all might be, so there's a broad range of issues that might lead to a dismissal for operational requirements.
Bruce, it might be worth just saying at this point, the courts have been absolutely clear that you can't squeeze in misconduct and incapacity into a retrenchment exercise.
Correct.
Yeah.
Correct. So what then, if you bear this definition in mind, what would constitute a fair reason to retrench? That was the first question that we posed in the outline. Well, I think the Concord judgment in Sakawa versus Woolworths is helpful, and it says a retrenchment must be operationally justifiable on rational grounds. So that's the test laid down by the Concord for whether there's a fair reason to retrench. Alan, that's quite legal jargon.
Yeah.
Won't you take us through some of the judgments which have effectively implemented that constitutional court test and give us a sense of the issues as to what would be a fair reason?
So there are many different dimensions of what's justifiable. And I want to start with just one observation about the consultation process. We use the term consultation, but in fact, the Act was amended some years ago, and the word consensus was replaced with a meaningful joint consensus-seeking process in an attempt to reach consensus. So consultation has been given a different kind of meaning. So what happens in this, what we call consultation process, is ideas are generated. Now, it sometimes happens that the employer can advance a possible settlement, and which is rejected. And what can happen then is it can be interpreted that the actual retrenchment is because the employees or the trade union refuse to accept that particular proposal. Now, what that does or can trigger the application of section 187(1)(c), which is about automatically unfair dismissals, which happens when there's a refusal, when the dismissal is a result of a refusal to accept an employer's demand in respect of a mutual interest matter. So you can see what I'm trying to say is a normal kind of proposal during this consensus-seeking process can be interpreted as a rejected demand.
Yes.
Yeah. Okay. And so the case I want to refer to,
So bring it up on the screen.
Yeah, please, is a Coca-Cola. There's going to be 2 Coca-Cola cases. In this first one, the employer offered alternative posts at lower wages, just so people could keep their jobs. And this proposal was rejected. And as I said just now, this was ultimately interpreted as being a dismissal because they refused to accept that demand, which is really a proposal. The Labour Appeal Court said that it did not fall under section 187(1)(c), because if a demand has got to be the main or dominant cause of the dismissal. Sure, in this case, the refusal to accept the lower paid jobs contributed to the dismissal, but it wasn't the main cause. There was an economic necessity. The sugar price, etc., had exploded, and Coca-Cola was in difficulty. So that's the key thing. What was the main or dominant cause of the dismissal?
And in this case, it wasn't the refusal to accept the demand. It was the operational issues that the employer was facing.
Correct. So the operationally justifiable reason was the economic. Yeah. So there's a second case, also involving Coca-Cola. You can see that the citation says Coca-Cola versus the Competition Commission. A merger of Coca-Cola with another company had been approved by the Competition Commission on condition. There was a condition that they could not have any retrenchments as a result of the merger. 2 years later, this economic crash happened, and Coca-Cola then found it necessary to retrench. And you can see this went all the way to the Constitutional Court, and the court then said that causation, what caused the retrenchment? You apply this but-for test. Would this happen but for that? That's the idea. And they basically then said, in other words, would the retrenchment have occurred if the merger had not taken place? And the answer in this case, yes, the retrenchment would have taken place anyway because of this economic crash.
Okay.
I want to deal with one other case, which shows that the reason for retrenchment, the but-for, is important. In this case, there was the employer needed to reduce staff, and I suppose chose an easy solution. Found one employee who had been working past her retirement date, and they said, we're going to now retire you. And the courts could see that what they were doing, they were retrenching, and the reason they were giving wasn't really honest. They tried to sell it as a retirement, and they said that this was unfair. You can't use retirement for an employee who has reached the normal retirement age if the real reason for termination was retrenchment. Okay. I want to then in the next case, just to spend a bit of a moment talking about the criteria that can be used to justify the retrenchments. Now, I think everybody knows that last in, first out, LIFO is the officially sanctioned criterion, but it's a very blunt weapon. It takes into account only one consideration, length of service. It doesn't take into account whether the employee fits into the culture, is helpful, is energetic, comes to work on Monday. And employers often complain to us in helpline queries if LIFO just leaves us with the dead wood. That's a rough way of putting it, but that's what I think has been said to us. And so there are attempts for employers to try and find alternative criteria. The Code of Good Practice on dismissal for operational reasons opens the door to other criteria which are based on length of service and so on, and qualifications. But the case I want to talk about next, which maybe you could put that up, Bruce, is the Umicore case. In this case, the employer was really, in going through this retrenchment exercise, it was really anxious to retain in its workforce employees who could work independently and on occasions work without supervision. This you can see that it was Umicore catalysts, they were laboratory people, and so they had to be able to trust employees who could work alone and independently. And so that was for them the key criteria, and LIFO didn't really meet that need necessarily. You couldn't assume that just because someone had longer seniority that they could work without supervision. So what they did was they decided to use behavioral assessments and a questionnaire. And this included performance appraisals, and also they considered, this is important, they decided to also look at disciplinary records and attendance records. Now, just to trigger your thought in this moment, they are considering misconduct historically as a criterion. And so now I want you to just put that in your mind. So the questions, and interesting, there was a lot of criticism by the courts on the way that the questions were framed. Often there was like alternatives in the questions, but they wanted a single answer. So that if you're thinking of going this line, you really need professional help to draft questions which are really going to be seen as fair and objective. But anyway, the questions were about trying to find out if you had a strong analytical mind, whether you were into multitasking, whether you had good communication skills, whether you're good at handling difficult colleagues, whether you took initiatives, whether you were enthusiastic. Now, you can just see as I spoke, and you can see my cynicism, you can see that how do you test these without being very subjective? You can can't you just see the selection group saying, oh, I know this guy, he's never enthusiastic. So you can see how subjectivism can just slip in. And both the Labour Court and the Labour Appeal Court found that these criteria, although they had worked hard at trying to be thorough, they were subjective and therefore unfair.
Shall I bring up some of the points?
Sure, please. Yeah.
So, I think the first point there, Alan, those are the criteria out of the Code of Good Practice, aren't they? So, I mean, the first point to confirm is that the Code of Good Practice does recognize as potential objective criteria more than just length of service.
Oh, yeah.
It does mention skills, it does mention qualifications, and then with caution, it goes on to say if you have to retain employees based on criteria fundamental to the successful operation of the business.
That's what's often called scarce skills, I think.
Yeah.
And I've seen that written into kind of retrenchment criteria, scarce skills. So this certainly opens the door to something far wider than LIFO. So I don't think you should be discouraged by this case, but it did exclude you can't have subjective elements. And that's in your mind, you've got to think, how will that selection committee look when they started to evaluate?
So it goes very much to the application of the criteria, and you've got to have an objective basis for applying these criteria.
Yeah, exactly. And also the point that I just signaled earlier on, you can't address poor performance through retrenchment. You can't at that stage start looking at their attendance records or their disciplinary record and say, well, that's going to be the basis for doing it. All right.
How about a company that's making money that wants to make more money?
Well, this goes against the very idea of the retrenchment is an act of the last resort. But because one of the criteria that you mentioned right at the beginning, economic reasons, it does happen, and maybe you could look at the next case. In this case, the general food industry's case, the employer wanted to outsource. They'd noticed all its competitors had outsourced a particular function, and to remain competitive, and therefore that was the economic reason, they decided to retrench for greater profitability. Now you can see this must really goes against our notion of dismissal being the last resort. But the Labour Appeal Court did say a company is entitled through economic restructuring to make a profitable centre, make sure it becomes even more profitable. And this rather dramatically, you can see, includes the need for flexibility in employees' terms and conditions of employment. So you can see what was happening here in this exercise. They were already requiring a change to trying to avoid a unilateral change to terms and conditions of employment. Yeah.
Okay, well, I hope that quick run through of some of the judgments gives you a sense of how the cases have applied this Concord ruling of going back to the Woolworths case, is it operationally justifiable on rational grounds? So there's some judgments. All those judgments are on work law, but I hope we've given you a sense of what would be a fair reason to retrench. The next question then is, well, if you're into a retrenchment, who do you consult with? Who do you have to consult with? What does the Act say about this? Let me share screen with you again. This is section 189(1) of the Labour Relations Act. And it begins this. It says, as soon as an employer contemplates a retrenchment. So the first thing you need to ask you is, at what stage would the employer be deemed to be contemplating a retrenchment? Well, I mean, often there's a strategic planning process in place that over a number of years, and they're looking at various options around restructuring or mergers and so on. And the unions would argue, well, it's too late to consult us at the 11th hour. You should consult us during it, or at the beginning, or as part of that strategic planning process, because then we can really influence whether there's a need to retrenched or not. But the courts have said no. They've placed the employer's obligation far down that process. I'm not going to call up the judgment, but it's a Labour Appeal Court judgment from 2008, Continental Tires versus NUMSA, which confirmed that it's only once the employer has discounted all other options and is now seriously contemplating a retrenchment, only at that stage does this obligation to consult kick in. And it says, the Act says, you must consult any party to a collective agreement requiring consultation, failing which, and those words are important, I'll come back to them, a workplace forum, if it exists, and any registered union whose members are affected, failing which the employees affected or their nominated representatives. So this is written, those failing which words are very important because this is a hierarchy of consultation. So if, for example, you've got a party to a collective agreement, a union that requires consultation, you don't have to consult the next two levels down, the workplace forum or any other union whose members are affected, or the employees or their nominated representatives. You comply with the section by consulting at the first level with that party to the collective agreement. Bearing in mind, you also, as you probably know, under Section 23 of the Labour Relations Act, you can conclude, an employer can conclude an agreement with a majority union and extend that agreement to cover all employees in the bargaining unit, and it amends their terms and conditions of employment. Now, so you can think about practical examples here. You've got a majority union, you have a collective agreement with it that requires consultation, you consult with it, you agree all aspects of the retrenchment with it, who's going to be retrenched, what criteria are applied, what severance pay is payable, the timing when the retrenchments are going to occur, and you extend that agreement to cover all employees in the bargaining unit, and a minority union that would have been consulted at the next level down is not consulted at all. And you can ask yourself how fair or unfair you think that issue is. Now, this actually occurred. If I can go on to the next slide. The AMCU case, Royal Bafokeng, and as you see, it all went all the way to the Constitutional Court. AMCU, in this case, was the minority union. NUM was the majority union. And the employer reached agreements with NUM on the retrenchment and extended it to all employees in the bargaining unit. And AMCU claimed that the first it and its members heard about the retrenchment was when they got their notices of termination. And they thought that was outrageously unfair. And they've taken this case all the way through to the ConCourt to dispute the constitutionality both of this hierarchy of consultation under Section 189(1) and the ability of employers and majority unions to extend their agreements to cover all employees in the bargaining unit under Section 23(1)(d). The ConCourt found that no, the consultation hierarchy and that section providing for the extension of collective agreements, non-parties, were not unconstitutional, and it fitted in with the majority approach to collective bargaining that's adopted throughout our Act. So that's the view of the ConCourt. Those sections have survived Constitutional Court scrutiny, but we think at a practical level, employers should consult minority unions on the understanding that their fallback position, if there wasn't agreement reached between all parties, including the majority union and the minority union, that the employer could fall back onto the agreement with the majority union and extend that to all parties. But at least the minority unions may have been involved in the consultation process and have had the ability to have their say. And it seems to us that there's no harm in doing that. And that's the kind of advice that we're giving to our subscribers via the helpline. Okay. Alan, do you want to talk about the notice to consult?
Yeah, I want to just make a preliminary comment before looking at a case. So Section 189 3 requires a notice to be sent out with a list A through to J of things.
And it says must, doesn't it?
You must. And then you've got to identify who's going to be retrenched, the timing, the proposed severance package, and so on. Now, balancing that with is the obligation, which Bruce alluded to. Yes, when the employer contemplates dismissal, this obligation is triggered. But nevertheless, the courses have said you can't come to the consultation process with a closed mind. You've got to come, if you can't have decided everything up front, otherwise the consultation proves nothing. So it's a really difficult problem for the employer. Section 189.3 says you must include A through to J, and yet at the same time the employer faces
inviting consultation.
Inviting consultation, but it looks like from the notice that everything's been decided.
So if I can jump in, the draft that we've given you on work law under that section which I showed you at the beginning of this webinar, I think it achieves a really good balance of, yes, if you have to say, have you dealt with A, C, F, or G,
Yeah.
You've ticked them all off. But it's written in a language and in a style that invites consultation. And it's quite a difficult thing to do, to comply with your obligations and to have this inviting consultation approach.
Yeah.
So you have a look at that example. You might find it helpful.
A case which I want to talk about is one where
Shall I share screen?
well, I just in a moment.
Okay.
I think, so the employer wasn't quite sure how many employees would ultimately be retrenched. It understood that in the consultation process there might be some trade-off, and we'll see just now that you could, for example, agree to a different process altogether. You could transfer somebody, you could find a job for them with an alternative employer, all kinds of things. And so the employer said 65 employees were going to be retrenched. That number had a huge significance in this case because it triggered section 189A, which triggered a facilitator. But the employer always thought it was going to be like 45. That wouldn't trigger section 189 or a facilitator. 189A. So maybe you can put up the case now, and in a judgment which Bruce and I both feel that is perhaps misunderstands the nature of the consultation process, which is meant to be, as I say, a meaningful joint consensus-seeking process. It said you can't send a notice of intended retrenchment to anybody beyond the people who you intended to retrench. So that the Labour Relations Act does not intend two categories of employees: those receiving a notice to consult and those the employer contemplates retrenching. We think that actually there's many instances where the employer is able in that consultation process to delay the retrenchments, to offer jobs at a lower wage, the kind of things we've talked about already in this workshop. And so we think that this was quite legalistic, that you have to know exactly in advance who will be retrenched, and that's only those people get the notice. I think it's not uncommon for quite a large section of the workforce to get notices as being it's potentially going to happen.
You don't think in this case that the underlying key issue was whether section 189A applied or not?
Well, look, yeah, I think
and
so.
The court wanted to get to a conclusion that 189A was to be applied,
Yeah.
and therefore it used this vehicle to get to that outcome.
Yeah, I think that's possible. But
Yeah.
anyway, yeah.
Okay. Our next issue is, what do you need to consult about? Again, I'm going to share screen. This is dealt with under section 189(2). And it says, as Alan said before, you've got to engage in a joint, meaningful, consensus-seeking process, and you've got to attempt to avoid retrenchments, minimize their number, changing their timing, or mitigating their adverse effects. And you've got to look at the method of who you're going to choose and what severance pay is payable. The Act also says if you have proposals in writing, you have to respond in writing. And And so that's what the Act says that you have to consult about. Shall we raise bumping?
Yeah, okay.
Okay. What is bumping? Bumping is when a person with longer service bumps or takes the job of someone with shorter service, and the person with shorter service is retrenched in place, even though it was the person with longer service whose job had become redundant. Bumping can be on the same level, which is called horizontal bumping. In other words, they're on the same status, pay levels, and so on. Vertical bumping is where someone might take the job of a lower ranked person who's paid less, has less status, a lower job grade, etc. Obviously, for bumping to apply, the employee has to agree to the new job, because it's obviously a change to their terms and conditions of employment. And whether the bumping is horizontal or vertical may then, if the employee doesn't accept that alternative job, then one looks at whether severance pay is payable under the Labour Relations Act or not. And there's just to mention, give you a heads up, the next news flash that is coming out in a couple of weeks' time deals with when severance pay is payable or not, and this where an alternative job has been made available to the employee, either with the same employer or with a different employer. But that's not the issue. That's for just a heads up of a news flash coming up. But the question that I want to ask all of you who are watching is, does the employer have to raise bumping as an option? What do you think? Well, let's look at what the courts have said on this. This Labour Appeal Court judgment, which came out fairly recently, Fisher Tube Technic, made the point that bumping is an integral part of LIFO, and there's an obligation on the employer to consult on bumping and to be able to justify why it will or won't bump under this, if it's applying LIFO as the key criteria. This case also confirms the various forms of bumping, being horizontal on a similar status pay, etc., or vertical at a reduced pay level, etc. So clearly there's an obligation on employers, if you're using LIFO as your criterion for retrenchment, to raise bumping and be able to justify your stance on bumping that you intend implementing.
Bruce, it might be worth just saying there are quite a few cases on work law on bumping, and another case, there's one other case where it's where the court said an employer doesn't have to bump in another division. If there are a number of divisions,
you're linked.
The employer can justify not bumping someone in another division, because you might be deciding to outsource and you want to resolve one particular division. Anyway, I think all I'm saying is there are a number of cases on work law which are worth looking at.
Yeah.
All right. So another, I think, more quite provocative aspect of retrenchment is whether or not you can retrench to reach employment equity sector targets. Now, in February this year, the Department of Employment and Labour released in a government gazette revised employment equity sector targets. And each sector has got a particular target given at different levels of management, which must be reached within a 5-year period. That's right. One of the things that happened before these targets were released was that Solidarity, the trade union, had referred a dispute on the whole Employment Equity Act to the ILO, the International Labour Organization, and there was a settlement reached. And the settlement, the detail of the settlement, form part of this government gazette. And in that government gazette, it specifically says that no employment termination of any kind may be effected as a consequence of affirmative action. It's worth saying that these regulations are still in draft form?
They are still in draft form. They asked for, there was public comment was asked for, and that period has expired. But obviously, with the elections and the GNU coming in, they've had other things on their mind, and those we haven't yet seen any word or have, and we've tried to find out when those sector targets may be finalised, and we've got no idea.
But the significance of employers reaching the sector targets is important for the BE certificate, which is the prerequisite for a tender with governments. So you can see how it might be tempting to retrench in a way to be able to reach your target. This is saying it may not happen.
So if that's carried through into the final version of those sector targets, obviously that puts an end to the debate on this issue. I just want to make, I attended a Labour Law conference, it was towards the end of last year, I think, or the beginning of this year, and a whole section of all these Labour lawyers getting their heads together were talking about this issue, whether an employer who was battling to achieve its sector targets could actually retrench to achieve those sector targets. And this obviously puts an end to the debate if these were carried through into the final version. All right, let's assume agreement is not reached. You've consulted, there's an obligation to apply fair and objective criteria. There's an obligation to meaningful consult. If you've reached agreement, that's fine. You implement the agreement and you go ahead. But what if you don't reach agreement? At what stage can the employer then say, well, I think I'm being fair, I've consulted, I'm applying what I think are fair and objective criteria, I've got a good reason to retrench, I'm going to proceed on a unilateral basis. Well, if you are governed by Section 189, in other words, you're not governed by Section 189A, it's not one of the bigger retrenchments that falls under 189A. There are no minimum time periods in the Act, okay? So you've got to, at some stage, take a view that I've consulted meaningfully, I'm applying fair criteria, I'm going ahead. And you would then do so, and you would be potentially put to the test by employees disputing the fairness of your procedure or the fair reason, and they would challenge you at arbitration or in the labour courts. But how do you determine when the consultation process has been exhausted? Well, there's a case on this. It's a NUMSA case, Labour Court judgment, and the test for genuine consultation in this case was, had the employees in the union be given a fair opportunity to suggest ways in which job losses might be avoided or the effects of a retrenchment ameliorated. So that's a judgment on this issue. Again, it obviously depends on the facts of each case. There's a further judgment, Gravenstein judgment, which emphasized that the consensus-seeking process is a dual role. Both parties have an obligation to see that this is achieved. And if employees or the union walk away from the process, they would not be able to, at a later stage, challenge the procedural fairness of that retrenchment. In fact, there's a Labour Appeal Court judgment, a fairly recent judgment, Johnson & Johnson, which went so far, because it was, I'm not going to go into all the details, but there was some procedural unfairness in this case. The Labour Appeal Court warned that if a union is obstinate and refuses to discuss the criteria for retrenchment, despite the procedural unfairness that might have existed, then employees would not be entitled to compensation under those circumstances. Yeah, that's just a few judgments that deal with the joint consensus-seeking obligation and whether or not employees in the union can challenge the procedural fairness under those circumstances. So I've spoken about Section 189. Under 189A, so if it's one of your larger retrenchments that falls under 189A, in those instances, certain time periods do apply, okay? There's as you know, probably know under that section, there are two options. One is for the parties either by agreement or either party to request the appointment of a CCMA facilitator. If one is appointed, then there's a minimum consultation period of 60 days. Okay. And by the way, the facilitation regulations, which have been included in the Gazette, they've added an extra that the facilitator should arrange a minimum of 4 meetings. So there's a 60-day time limit which bars you before you can give notice of termination. Even if a facilitator is not appointed, there's effectively still a 60-day limit. There's a limit of 30 days before you can refer a dispute to the CCMA, and then there's a 30-day period for a dispute to be processed at the CCMA. So either way, under section 189A, there's a 60-day effective bar on you giving notice of termination, which is unlike a retrenchment only covered by section 189, which has no built-in 60-day time limit barrier. By the way, I was meant to mention at the beginning of the webinar that if you have any questions, please use the Q&A function at the bottom of your screens, and we'll deal with those questions at the end of the webinar. I see there are some people who have asked questions, and well done, you've used the Q&A function at the bottom of your screens. But please, if you have any questions, post them there, and we'll then deal with them at the end of our input. So, yeah, I think I've covered then at what stage the employer can act on a unilateral basis.
So I want to just talk a bit about procedural unfairness, and the way that the Labour Relations Act is designed, and in the bigger retrenchment, section 189A, there's a particular procedure where you've got to challenge procedural unfairness early on. And you can see the reasoning. If, for example, has made a technical error, the Act requires an employer must reply in writing to proposals made by the union. Now, say the employer doesn't do that. And so it's like a technical error, which might result in procedural unfairness. To wait until the very end and then to challenge the procedural unfairness, the employer can't really correct it. And so really wisely, I think, the section 189A has got a special provision which requires procedural unfairness to be disputes along those lines to be referred very early on, so that the employer's got a chance to fix it.
And you can't then raise those procedural issues later when you challenge perhaps the substantive fairness of the retrenchment.
But in one case, the issue arose whether that applied to all retrenchments. In smaller retrenchments under section 189. And the court has said very, very firmly that for those retrenchments, it's this Regenesis case, which went all the way to the Constitutional Court, that it is possible in a smaller retrenchment, section 189 retrenchment, to challenge procedural unfairness at the late stage.
Okay.
All right.
So, but just to, this case did highlight the different channels under 189A, didn't it?
Correct. And substantive fairness. So, so that's, I think, to be aware of. Not just be aware that procedural fairness must be challenged at an earlier stage. The timelines are all spelled out in the Act. There's one other issue which I think I need to deal with along the timing of things. Bruce has said that there has got to be, if it's a larger retrenchment, a facilitator who must, as Bruce said, arrange 4 meetings. Now you can imagine after 4 sessions of facilitation, which is a process which I don't think is even defined in the regulations. But I think we all understand what the word facilitation means. A person who's like a chairperson, who I think there's some aspects of even mediation in the facilitator. Whether having gone through 4 meetings, you can then simply proceed with going to the Labour court, or must you now do something which the Act says you must go to conciliation first. I think for most of us would say, well, conciliation at that late stage. If a facilitator in 4 meetings hasn't got any kind of settlement, it's not going to happen now. But the Labour courts, in fact, the Labour Appeal Courts in NUMSA versus SA Technical was quite firm. The way the LRA is designed is you don't get to the Labour Court unless you have referred the matter first for conciliation. So all retrenchment disputes must be referred to conciliation, and even those that have gone through a facilitation process. You know, I think we know that most employers who are have got a Section 189A retrenchment on their hands, they're really wanting to speed things up, and this really slows things down again.
Yeah, but I mean, the Labour Appeal Court didn't make the point of the difference between the two, didn't it?
Yeah. So facilitation is pre-dismissal process to avoid retrenchment. Conciliation is a post-dismissal process to agree on fairness. They're 2 different inquiries.
Yeah.
Yeah.
Yeah. All right. So we've taken you through a whistle-stop tour of the key elements in a retrenchment process. And we've covered some of the landmark judgments in the process. And I hope we've given you a real sense of some of the practical problems associated in the retrenchment process. And we've given you some tools and ideas as to how you would deal with those. Don't forget the retrenchment guidelines on the Worklaw site. There are drafts there. I didn't take you through it all, but there are draft notices to consult. There's draft agreements. There's draft letters of termination of employment. So all that material is there for you to use and look at if you get into a retrenchment. So, Alan, let's deal with any questions, or are there any points that you want to raise before we do so?
The recording of this webinar will be available.
This will be available on the Worklaw site. We will put up this and our notes. We've got an outline of the material that we've used. It's about a 6-page notes that Ellen and I have been glancing at occasionally. We'll put those up as well on the Worklaw website in the next week or so. So that will be available to you as well. Let's look at some of the questions that you might have posed. They're not many. What happens, I don't know if you can see these on your screen, I don't know if you can or not. What happens if the other party walks out during the consultation process and refuses to participate when called upon to participate? Can the employer then retrench unilaterally?
Well, I think the one case that Bruce referred to was quite clear that consultation is a dual duty, and there are the other decisions where where the one party walks out and doesn't reappear, the employer can then unilaterally terminate, and it certainly won't. You can't challenge then the procedural fairness of the retrenchments. You could possibly challenge the substantive fairness.
Correct. I mean, don't forget that fairness is always there are 2 legs to fairness. Procedure. Have you followed a fair procedure? And if you walk out of the process, you are hard pressed to challenge the procedural fairness. But there's also substantive fairness. Have you had a fair reason to do what you're doing? And the party could still challenge potentially the substantive fairness in that case. Does bumping not raise the risk of a junior retrenched employee now saying that originally their job was never affected? I suppose it does. The person's been bumped, but bumping has been recognised, as we've said, by the Labour Appeal Court as an integral part of a retrenchment process. Based on LIFO service. So someone's got to go. And if, yes, it seems unfair, this person's doing a job, that job continues to exist, but that person's got shorter service. So there's an element of unfairness somewhere there in the process, and that someone has to lose their job. But the thinking is the person with shorter service is going to be the person who is retrenched. And certainly to apply bumping fairly would not be an unfair termination of employment if it was done fairly and properly. Is the 60-day period for the consultation period, or must there be a 60-day period before termination? Seppo has asked the question. Seppo, what you're talking about under 189A, what the Act says specifically is that you cannot give notice of termination within the 60-day period. So if someone's on a month's notice, by argument's sake, the effect of 189A is that the person is effectively kept in their job for 3 months. 60 days for the consultation process, and then serving out their notice of termination would be a further month. So effectively, one of the consequences of 189A is that it pushes out any termination by 90 days, including the notice period that the employee would be subjected to if they were on a month's notice.
Yeah.
Yeah. All right. Are there any other comments? I'm going to give you a last chance to raise any questions. I'm just going to go back. Oopsie. I didn't. Sorry, just to share screen with you. Just to those of you who are not WorkLaw subscribers, who might be interested in having a look at WorkLaw, we do offer a free 3-day trial. Just email me, bruce@worklaw.co.za, and we'll give you access to our range of services for a period of 3 days, and you can have a look and see whether this interests you or not. Yeah, and these webinars are part of the process that we update our subscribers. We have a couple of these a year, in addition to the weekly news updates that we provide and the monthly newsletters and newsflash services as well. So your last chance, if there are any other questions that you want to ask. There is one more that's come through. Okay, just someone saying that he was Alan's first year student, maybe some time ago, and nice to reconnect.
Thanks for connecting, Stefan.
Yeah. Thanks for all of you for attending. We hope that you found this helpful. Please give us feedback on issues you'd like us to cover at other webinars in the future. Please email me, bruce@worklaw.co.za, and we will certainly take note of any topics that you want, because we're always looking for topics. We tend to do a case law update in the first half of each year in about April or May, and then our webinar in the second half tends to focus on a particular subject or topic that we then deal with. So thanks for attending. I hope you found it worthwhile, and enjoy the rest of your day. Cheers.
Cheers.